Hi, I'm Kristina Bergsten with the animal law firm where we are fighting for the underdog. Today I would like to talk to you about what to do if you live in Pennsylvania and your dog has been accused of being dangerous. It's often called harboring a dangerous dog, and then they also have a secondary charge of confinement, failure to confine. So if you find yourself being charged with one or both of these things, usually both, then give us a call. The other thing to keep in mind is that typically Pennsylvania does not impound dogs on the first offense. It can happen, but I haven't seen it happen yet. But if your dog is accused of being dangerous because your dog bit the neighbor kid or ate a chicken or bit another dog, whatever it may be, you will get a court date and it will be in your magisterial district court. A lot of times these magisterial district court judges have never actually been a lawyer before. Sometimes it's just like some guy who thought it would be cool to be a judge. A lot of times they're usually law enforcement professionals, like former law enforcement professionals. Sometimes they're not. Sometimes, like I said, they're just some guy in a robe. And the magisterial district court system is not designed for defendants to ever win. It doesn't matter if I represent you, if another attorney represents you, if Johnny Cochran represents you, it doesn't matter. You're gonna lose at magisterial district court, and you just have to walk into that knowing that. If for some reason you decide you want to handle this case by yourself, what you need to do is you need to subpoena the records. And I say this because you're not entitled to discovery in summary offenses. So a summary offense is what harboring a dangerous dog is charged at. So it's less than a misdemeanor. It's a lower level offense than a misdemeanor. It's basically the equivalent of a speeding ticket. Even though the penalties are very, very severe. Like you have to get a 6-foot tall fence with 3 feet being underground. So that means a 9-foot tall fence in reality. You have to get a 6-sided enclosure. So basically a cage with a roof and a floor. If your dog is ever outside, your dog has to be on a leash and muzzled. You have to pay $300 per year to the Pennsylvania Department of Agriculture to register your dog as dangerous. You have to get your dog microchipped, spayed and neutered if not already, and you have to turn the microchip number over to the Department of Agriculture. You have to get a minimum $100,000 insurance policy for your dog, whether you rent or own. And failure to follow any of these rules at any time during the dog's life can result in further charges where your dog can get taken away from you and euthanized. Pennsylvania does not rehome dogs. Pennsylvania only euthanizes dogs. So if your dog is facing euthanasia, definitely give us a call because we can help. We just need to get in as early as possible to try to find a way to save your dog. It doesn't necessarily mean your dog is going to go home with you, but at least we can save your dog's life. So give us a call if you're facing euthanasia in any state. Now, at the magisterial district court level, call an attorney. You can file to have records subpoenaed yourself. You have to subpoena the dog warden, and then you sometimes have to also subpoena the law enforcement officer that responded. Sometimes it's not always the dog warden that responds. A lot of times it's like local police or the local sheriff's deputies who respond, and then the dog warden gets involved later and is the one that issues the charges. So you might have to subpoena both. You can do that yourself. It's not too hard. Then the court issues the subpoena. But we do it all the time. So if you see out there that records need to be subpoenaed, then give us a call. We're happy to take over. So like I said, you've got to keep in mind that the magisterial district court, you're going to lose. Like I said, it doesn't matter if I represent you or if you go in and represent yourself, you are going to lose. So what happens is we get the call. We subpoena the records, we talk to the dog warden, we see if we can resolve the case with a plea agreement to a lesser charge. Sometimes we can, sometimes we can't. It just depends on the disposition of the dog warden, how much the dog warden hates dogs, the facts of your case, how severe the bite was, things like that. If we can reach a resolution that you're satisfied with, then we will enter into a plea agreement and the case will be over with at the magisterial district court level. If we cannot reach a plea agreement that you are satisfied with, or if the dog warden just won't do it, then we proceed to trial in front of the magisterial district judge. I do not ever have the client testify at that point unless there's something very compelling about the, your particular case that would require, or that would, might persuade the judge. I usually don't even have you testify. There is no record at this level. Yeah, you know how on TV you hear people say, "Oh, for the record, Your Honor." Well, that means that it's being recorded, right? Either somebody's sitting there with a little typewriter, or they're like recording it through a digital audio recording system, which never happens at magisterial district court. So the only way to get it recorded is if you personally pay for it. So, I lost my train of thought. So anyway, so there's no record, so there's no point in having you testify. But we can't use the testimony of the victim witness against them at the next court level unless you pay to have it recorded. Anyway, so then we go forward with the trial, and then after you lose, we just go right outside, we pay the fee for the appeal, and then we appeal the case right away, and then you get a court date, usually like 3 months after you file the notice of appeal. You have 30 days to file a notice of appeal, but since you're already in the courthouse, you might as well just do it there and then anyway. And then the court gets kicked up to the county court level, which is, fill in the blank county court of common pleas. And that is where we will get a prosecutor assigned to your case. And if we didn't get discovery at the magisterial district level, then we'll get it here. In theory, I have had a prosecutor who's being a total D-bag, and he is just like fighting me tooth and nail for me to not have discovery, which is just like really rubbing me the wrong way. Anyway. So that's neither here nor there. So try to get it at the magisterial district court level. And then we'll again, have a trial and we'll try to resolve the case with the prosecutor. If not, we'll have a trial where we'll get a dog expert that I work with to come in and testify about the dog's level of aggression and things like that, whether or not the dog was provoked. So in short, in Pennsylvania, you don't have to worry as much about your dog being impounded as you do in New Jersey or Colorado. It's still always something to be concerned about. And anytime you get a charge involving your dog, the best course of action is always to fight it, because you don't want to have those restrictions following you or your dog around. And you don't want to, create a situation that could set your dog up for failure later. So if you are in Pennsylvania and you're charged with ownership of a dangerous dog, harboring a dangerous dog, give us a call, 215-664-8448, or visit our website at theanimallawfirm.com to set up a free consultation and see if we can help you. That's it for today, underdogs. Thanks for tuning in, and I will see you next time.